distinguished personages of the All India Catholic Union, and other distinguished people present here today. It is indeed a pleasure for me to be invited by the Catholic Union to address you and to talk about contempt of court and public interest litigation. As you all know, about 70 years ago, when we founded our republic, we gave ourselves a fine constitution in which we established democracy in this country. We gave our people various fundamental rights, which are supposed to be inviolable. The right to equality, the various civic rights under Article 19, and the right to life and liberty, which has been expansively interpreted by the Supreme Court to include the right to live with dignity. We also established several institutions in order to protect our democracy, in order to protect our fundamental rights, in order to protect free and fair elections, in order to protect our public exchequer. The most important of all these institutions is the judiciary, the higher judiciary, the high courts and the Supreme Court. And the role of these courts, the higher judiciary, is not merely to dispense justice and decide disputes. It is one other very important role is to protect the Constitution from being violated by the executive or the legislature. It is also to protect fundamental rights of the people and to ensure that the executive and the legislature remain within the bounds of their powers. So the judiciary has been given a very important responsibility and enormous powers under the Constitution, and they have also declared that even constitutional amendments made by 2/3 majority of both houses of parliament cannot violate the basic structure of the Constitution, which includes equality, secularism, an independent judiciary, etc. Now, we ask this question as to what is the state of the judiciary. So in order to ensure that our institutions function in accordance with the role given to them, assigned to them by the Constitution, it is important in a democracy that people should be able to freely discuss and critique these institutions, including the judiciary, so that people should be able to speak freely about what is the state of affairs in the judiciary, how much corruption is there in the judiciary, what is the system of delays in the judiciary, how accessible is the judiciary to the people, what is the state of independence of the judiciary from the government. Because in order for the judiciary to perform its role of protecting fundamental rights as well as ensuring that the executive and the legislature remain within the bounds of their powers, it is important that the judiciary remains completely independent of the government and the legislature. So, people have the right and indeed the duty to constantly critique all institutions, including the judiciary, and therefore they must be able to speak and discuss freely what is happening in the judiciary. Now, unfortunately, you see, when I gave those, or when I tweeted those 2 tweets, which became the subject matter of contempt proceedings against me, all that I was doing was to critique what I felt was going wrong with the Supreme Court. In one of the tweets, I pointed out that it is very, I just expressed my anguish at the fact that while the Supreme Court was in lockdown mode and functioning only through video conferencing with very few cases being listed and heard, and that too in a very unsatisfactory way, at that very time, the Chief Justice, who was responsible for the administrative functioning of the Supreme Court, he was seen to be sitting on a very expensive motorcycle in a public place belonging to a BJP leader without any mask. The second tweet was where I said that when historians look back to see how democracy has been destroyed in this country without even a formal emergency, they will note the role of the Supreme Court and particularly the role of the last 4 Chief Justices. Now, that is also an expression of my opinion about what has gone wrong with our democracy, with our judiciary, and the role of the last 4 Chief Justices in allowing the destruction of our democracy in the last 6 years. Unfortunately, the Supreme Court felt that these tweets constituted an attempt to denigrate and destroy the dignity of the court and destroy public confidence in the judiciary, etc. And therefore, they held me guilty of very serious contempt and ultimately imposed a punishment of 1 rupee fine. And in the absence of that, 3 months in jail and 3 years from being barred from practicing in the Supreme Court. Now, that's the problem with this particular part of the contempt law. See, contempt of court has broadly 2 parts: civil contempt, which means disobedience of a court's order, and criminal contempt. Criminal contempt again has 2 parts. You see, there's no problem with civil contempt. Court's orders should be obeyed. If they are disobeyed, there should be some punishment against that. Criminal contempt has 2 parts. One is interference with court proceedings or with the administration of justice. This also, there is no problem. For example, if a person doesn't allow the court to proceed, dances on a judge's table, or if a person threatens a judge or threatens a witness that if you decide in a particular way or depose in a particular way, I will do this or that to you, that is certainly interference with court proceedings or with the administration of justice, and therefore that also should be punishable. The problem is with the second part of criminal contempt, which is scandalizing the court or lowering the authority of the court. Now, this is something which is not defined. It's very vague. Any criticism of the court or a judge can be treated by that court or that judge to be scandalous in nature or lowering the authority of the court, etc., which is what they did in the case of my tweets. So, and in this jurisdiction, the judges sit as the accuser, the prosecutor, and the judge. Therefore, it's a very dangerous jurisdiction, and that is why it has been done away with in almost all civilized countries. It survives in India. We filed a petition challenging it on the ground that it is too vague and undefined, and it's a very dangerous power to give to somebody who sits as a judge in his own cause in this jurisdiction. Unfortunately, that petition filed by Mr. N. Ram, Mr. Arun Shori, and I was also listed before the same judge who was dealing with my contempt cases, that is Justice Arun Mishra, same bench. And therefore, we had to withdraw it because we knew their views already. And we were given permission to file it in some high court, which we will. But that's one aspect of the contempt of court law which needs to be reformed. Now, Now coming to public interest litigation. See, public interest litigation is a very, very important instrument which has been fashioned by the Supreme Court. And the primary basis of that is their interpretation of Article 21, which is a very expansive interpretation, where they say that the right to life and liberty does not merely mean the right to live an animal life, but the right to live with dignity, which means that every citizen must be given and provided by the state at least basic medical services, at least basic education, at least food, water, shelter, etc. So, and they have also held that the right to live in a fair environment, in a corruption-free society, is also part of the right to life and liberty. And while exercising the jurisdiction of the court to ensure that people are given all these things which are needed to live with dignity, the court uh, uh, started passing orders on public interest cases or public interest issues brought before it, initially on matters relating to environmental protection, thereafter on matters relating to the civil rights of people, thereafter on matters relating to socio-economic rights of people, and thereafter on matters relating to corruption and accountability of public servants. Apart from this, one other further expansion of this public interest jurisdiction, public interest litigation jurisdiction, was to even pass orders for institutional reforms. For example, when they felt that corruption has to be investigated by the CBI, and the CBI was controlled by the government. Therefore, they said, unless we free the CBI from excessive government control, we will not be able to deal with corruption. The CBI will not be able to investigate corruption in high places if they are controlled by those very people whose corruption they are supposed to investigate. So they passed orders in that Vinit Narayan case, or that Hawala case as it is called, for institutional reforms in order to make the CBI more independent. The same thing they did in that Prakash Singh's case for police reforms, because it was found that the police was also being excessively controlled by the government and being used as an instrumentality for harassing its political opponents, for not investigating cases against itself, because the police is supposed to be investigating crimes, and so on. So therefore, they passed a series of orders for institutional reforms of the police. Unfortunately, those orders which were passed 14 years ago in 2006 have still not been implemented till today, with the result that the police in most places in the country still functions as a political instrument used by the ruling government in order to harass people. Today, the Delhi police is being used to harass the anti-CAA activists who were totally peaceful activists, some of the finest activists, just because they were opposing something which the government wanted to push through. Same way, the National Investigating Agency is being used to harass some of the finest activists in the country, human rights activists in the country, like Sudha Bharadwaj, Anand Tumle, who were merely fighting for the human rights of people. The NIA has now arrested them on some absurd charges, obviously at the instance of the government. So these are still continuing problems which we need to solve. We have been going to the court saying that, look, your orders for police reforms have not been implemented. Please take contempt action against these ministers and these governments, etc. But unfortunately, the court has not acted on that. We need police. We need institutional reforms even in the election commission, because unfortunately today the election commission has also become an instrument of the government, is no longer independent, and part of the reason is that the election commissioners are appointed by the government, and there is no broad-based independent committee to select the election commissioners, with the result that highly compromised and partisan people are being appointed election commissioners, and the election commission has become an instrumentality of the ruling party. So we need many more PILs of all kinds. For example, the right to work, the right to employment should be a right which people should have. So a NREGA type of scheme where at least one person from every family is guaranteed 100 days employment at minimum wages in rural areas, that should be extended to all adults, and it should be increased to at least 180 days in a year. That's a basic minimum right of every citizen, every adult in this country, to at least get employment on minimum wages for at least half the year. So that should also be the subject matter of a future PIL. But you see, unfortunately, what the success of these PILs depend very critically on the independence of the judiciary from the government. Because in all these cases, the orders that need to be passed by the Supreme Court are usually orders which the government resists. And therefore, the orders have to be passed despite the opposition of the government. And therefore, you need the judiciary to be independent. In order to do this PIL jurisdiction effectively, we need a very independent judiciary. Unfortunately, one of the major problems today is that in this kind of almost fascist and very strong government that we have had in this country for the last 6 years, the Supreme Court's independence seems to have been compromised. And that is why we are seeing that either important PILs or important cases such as the petitions regarding electoral bonds or about challenging the CAA or challenging the abolition of Article 370 or conversion of Kashmir into a union territory, these are not being heard. And even those which have been heard, all the orders are going in favor of the government, like in the Rafale case or the Ayodhya case, etc. Orders which to my mind are totally wrong, but they have gone in favor of the government. And in my view, because the independence of the Supreme Court today has been compromised. So therefore, the success of PILs in future will depend critically on to what extent we can rescue the judiciary or the Supreme Court from its current crisis. And its current crisis indeed is the lack of independence. And one of the reasons for that is because the Chief Justice has enormous powers as master of roster. He can decide which politically sensitive case is to be heard by which bench. And since the predilections and affiliations of judges are known, therefore, if the Chief Justice comes under the control of the government, he can virtually get every politically sensitive case decided in the way the government wants it to be decided. This is a serious problem which Justice A.P. Shah recently wrote about, that we need to do away with this power of one person, that is the Chief Justice alone, to decide which case is to be heard by which bench. This power, firstly, the power to allocate benches by jurisdictions should be vested in at least the senior-most 5 judges together. Secondly, if there are, say, 4 benches dealing with a particular kind of case, they need to go randomly to any of those 4 benches. So these are certain reforms which are required in the judiciary. Of course, the judiciary requires many more reforms. We need to make the judiciary more accessible to the people, because today common people do not have the funds to engage any lawyer. We need to have a simplified system whereby people can access the courts without lawyers. The Gram Nyayalayas were supposed to be such courts, but they have not been implemented. Secondly, we need quicker disposal of cases, for which we need more courts and better judges, for which we also need a better system of selecting judges. We need to have a proper, robust system of accountability of judges, a proper in the hands of the government. Government should have no role to play in giving post-retirement jobs to judges. So therefore, all these reforms are required. And for that, we will need to have a people's movement for judicial reforms, because neither the government nor the existing judiciary is interested in these judicial reforms. Unless there is public pressure by way of people's movement on judicial reforms, these reforms will not take place. So those are certain things that need to be done. This is all that I wanted to say. I again congratulate the All India Catholic Union, and I my best wishes for all of you. Thank you.